own conclusions on these lines, that there's been an infraction of this and that and that and that shortcomings on Stolz's own statement. Here are the shortcomings or matters that are disciplinable, and we make a negative recommendation that she and Mackenzie be disciplined. Why has that not happened? And why can that not happen?
This question, the SC has canvassed it. We spoke about it a lot of times. The standard operating procedure of IPID doesn't allow us to make a recommendation without the completion of the case. So when we make recommendation is when the investigating officer says that everything is here in the docket, and you compile your report to DPP and the stakeholder, which will be EMPD or SAPS. So we do these reports when we finalize the matter, because the system, you must feed this recommendation to IPID system, electronic system, and it is signed by the provincial head that you have finalized the matter. So even when the auditors comes, they will say, in this matter, everything was done, and it was done on this date. So when you see our PDMs, after we have done our memorandum to DPP and SAPS, DPP might not be satisfied. The office was convinced that the matter is completed, but the DPP can say, no, Magagula, you have not yet finalized the matter. Go and do 1, 2, 3, 4. But already on our system, it will be finalized because we're convinced that everything was done. So I do not know if I answer your question. The predicament, even now when I live here, is because I can do the recommendation, but will my boss sign it because the standard operating procedure says that you must do recommendation when the matter is finalized?
I've not seen the prescript that you are referring to, but depending on the language, as presently advised, I feel that IPID is unduly constraining itself in this sense. If this is about the completion of investigations, I do not understand why you should tie EMPD investigations to investigations intended for the criminal process. If on what you have done, you are of the view that enough is now in existence for purposes of pursuing a disciplinary process, why can't you say investigations are now complete insofar as the disciplinary process is concerned? And then you are able to fill in that electronic document, and you are able to convince your superior to sign off on that. Are you perhaps not unduly constraining yourselves? Are you perhaps not interpreting the prescript you are referring to wrongly?
Yeah, I agree with you, Commissioner, that as soon as we establish that there is a prima facie case, we should make
that is exactly my point.
Yeah.
Practically, you may easily establish that there is a prima facie case for purposes of the disciplinary process.
Yes.
Which means that with regard to that process, the investigation is complete. So why can't you close that off, seek your superior's signature, and fill in that form? And where it says, is the investigation complete? You say yes. Why can't you do that? Sitting here now, I don't understand why not, unless you explain it.
And maybe to add to that if it's quite conceivable that you may, I know you have just said to us that you have means of getting these witnesses, additional witnesses that have disappeared, but it's conceivable that you never ever find them. And the way you describe your standard operating procedure and your reasons for not having recommended yet disciplinary action to the EMPD, that could be the end of this case, because you never get those witnesses. And so you have officers where there's a prima facie case against them, which gets proven on a balance of probabilities, and in respect of whom your witness statements are irrelevant, right, for reasons that I've earlier discussed with you, but they actually walk scot-free because your standard operating procedure says until you've bedded everything together and you have a docket that goes to that's approved by the DPP, you may not recommend to the EMPD to institute disciplinary proceedings. Something is seriously wrong if that is what your standard operating procedure says or requires of you.
I agree.
But bear in mind that I say you may well be misreading that standard operating procedure. So do you want to comment on all this? I'm sure you still remember everything I said, and you remember what my co-commissioner, Commissioner Baloyi, has just said. Do you wish to comment on all that, please?
In terms of me maybe not understanding the standard operating procedure, I'll be saying it means that most of the caseworkers of IPID, if the point is that we are not understanding that standard operating procedure, including our boss who must sign the said recommendation, because it will be written, definitely so.
Yeah. You see, the simple point is this: what may have to be proved for purposes of the criminal case may not necessarily be the same as what needs to be proved in respect of the disciplinary process. Needs to be satisfied, has been satisfied. It just doesn't make sense to bind them together like that. Do you get what I mean?
I get it.
Do you agree that you may possibly be misreading the standard operating procedure? I'm suggesting this to you, not having read the procedure, but you accept that you may well, because otherwise,
I accept.
Otherwise, whoever framed it would have framed it very stupidly.
Yeah, I accept.
Thank you.
And do you accept, sorry, Miss?
Yes, ma'am.
Do you accept that if you have read it correctly, if what you're telling us is in fact what it is, then it's a major flaw in that standard operating procedures and it has to be reconsidered?
Yes.
So that it permits you to do what the chair is suggesting should be the way things are done.
Yes, I agree. And it will be fruitful.
Yeah. And we are not blaming you. We are not blaming, as we understand it, you are suggesting that this is how all of you operate, you know. Yeah. Ms. Sidlo, perhaps we should throw this one back at you for you to please follow up on the actual content and true reading of this procedure.
In fact, we've made a note. These are some of the documents when Mr. Kiafela Kai returns for the IPID stream. This would form part of his bundle.
Yes, yes.
To talk generally about IPID and the SOPs and any other regulatory instruments they have. However, although I'm hesitant to tell the commissioners this, we have tracked it down. It's an SOP dated 25th March 2019, but I won't put it to the witness. The witness hasn't been confronted with this document. It would be grossly unfair, but we will pick up the issue. And I suggest so confident that it need not detain us regard being heard to the peculiarities of this particular case. Yes, it's still a live issue that must be answered in regard to the others. So if I may just deal with the witness, confining ourselves to this case, to address the very concern that the commissioners raise, that why could disciplinary processes not be initiated within EMPD regarding this Patfontein matter, and to determine whether failure to do so was caused by the delays on the part of IPID. The reading of the statement doesn't fully answer that question, but the reading of the docket, I think to a large extent does. So perhaps if I take the witness through those documents.
Yes, Ms. Law.
Thank you. Before we do so, Chair, my very able attorney has assisted with SAP 299 or 229. I don't know whether it's experience in being arrested or in arresting or solving criminal cases, but that is to be found in TLM 1 at page 33. Mr. Magagula, if you go back to your annexures file, remember the annexure file we're working through looking at your docket in this Patfontein matter? Please go to page 33. Are you there?
Yeah.
I'm advised, and I see at the top right corner, unfortunately the page number is imprinted over, that it reads SAPS 299. Is that that SAP register we spoke about earlier?
Yes, it's the register that I spoke about.
Okay, the chair had asked us to locate it, so it is located. So I don't know if the chair would like to consider some questions on this SAP 299 that Ms. Kisha Stolz references in her statement to say the goods were returned to the lawful owner.
Not at this stage.
Not at
I'll
this
see
stage.
if I can.
Then just
apply
to
my
note
mind
it for the
to-
record.
Thank you.
Then, Mr. Magagula, in order then to deal with the issue that the commissioners engaged you on regarding delays in institution of disciplinary processes within EMPD, we need to run forward into your statement, and I would like you to turn to page 19 of your statement. At page 19, paragraph 85. You deal at paragraph 85 with ongoing, you say, communications with the institutions whose members we investigate. You see that?
Yeah.
On page 19, you see the last line of page 19 at
Yeah.
85?
Yes, I see.
Please read that last sentence starting with all these institutions and then continuing overleaf.
All these institutions do not require a directive from IPID to initiate their own disciplinary investigation. Where the institution become aware of the relevant facts, they act on them through their own internal processes.
And then, bearing that in mind, please turn to page 42 of the annexure bundle. At page 42, I find a statement, again on the Ekurhuleni Metropolitan Police Integrity and Standards, form. This F1 goes forward to page 45. It's signed on the 19th of February 2023. Now we must remember that the incident occurred on the 8th of February 2023. And it would appear that EMPD was able to obtain a statement from Ms. Stolz, who's one of their members involved in this incident, on the 19th of February 2023. She relates the incident, as she remembers it or knows it, And just to highlight a few aspects, at page 42, line 3, second sentence starts regarding this load. Allegedly, the load was meant to be in Congo, but had been stolen and was currently on a plot in Patfontein. If I go further, at page 43, for instance, about midway, or just slightly below midway of that page, there is a sentence, she's talking about the shop owner, and we know now it's Yusuf. She says, I know who the person was referring to. This is, I guess, the informant she's talking to, allegedly, and was aware that Yusuf had been arrested in 2022 for possession of stolen goods and possession of stolen trailers. Then at 43, then she goes into detail about this vehicle, this truck, and her own visit to the pound. Midway, page 44, she states, I went to Boksburg Pound and explained to the officer that the owner of the truck was a person by the name of Yusuf, and to please call me if Yusuf arrived so that I could arrest him. During the week, I was informed by the EMPD Pound office that someone had come to the pound to collect the horse and trailers, but it was not Yusuf, but the officer refused them to collect. 3 lines down, I refused, and I have also been contacted by persons not known to me on behalf of Yusuf to release the horse and trailer for 20,000 bribe. I refused. Yusuf is wanted by a colonel from Crime Intelligence Jamiston for questioning regarding the theft of goods as well as truck hijacking. I'm to contact the colonel as soon as I have Yusuf in custody. And then it goes on at page 45, where she alleges that Yusuf wants to bribe her and has threatened her and her career. Now, this statement she makes on the 19th of February, 2023, do you confirm that?
I confirm.
If you go further at page 46, it's a similar statement, again on an EMPD, Integrity and Standards letterhead. This is by Adrian Mackenzie. Yes. The other officer we know was involved. On this, in this document, at the page 46, Mr. Mackenzie notes, on 8th February 2003, at about 23 hours, I was contacted by Constable Stolz, who informed me that she had received information about a suspected stolen load that was in Patfontein, and that she had informed our supervisor and that we must proceed to Patfontein. When we arrived at the plot, we saw a horse and 2 trailers. Do you see where I'm reading?
Yes.
Incidentally, before I continue, do you know who their supervisor is?
Their supervisor, I know him as Julius Mkwanaze after their arrest in Benoni case.
Okay. Then if we go to page 48, then he gives his version of the incident. At page 48, importantly, the start of the page reads, we reached Boksburg where the owner of the load, who gave proof of ownership and relevant documents, took possession of his stock. And similarly, like with Ms. Stolz, no, not similarly, Ms. Stolz deposed to this on the 19th of February to IPID, to EMPD, and Mr. Mackenzie on the 24th of February, 2025. Now, in your view, considering that by that time EMPD was armed with the complainant statement made to EMPD, less than 2 weeks later, EMPD had obtained the statements of the implicated officers, and also regard being held to the content of their respective statements. Was that not sufficient for EMPD to trigger its own internal processes and start an disciplinary investigation, as you say at paragraph 85 at the bottom, that all these institutions do not require a directive from IPID to institute their own disciplinary investigations? Where the institution becomes aware of the relevant facts, they act on them through their own internal processes.
Yes, they have enough evidence to start their own disciplinary action. Even before I took over the investigation, they have all the facts. Because this person who obtained this statement works in that unit, which takes disciplinary action against members. Because it says, if you look, supposed to have taken, they are aware even before IPID knew about this matter.
And if I can take you then further to page 90 of the same file, we're still in TLM 1.
Page 9?
9090.
Okay.
And this document is on the EMPD and City of Ekurhuleni letterhead. It is directed to the head of Detective Services, South African Police Service. It states that it's from Owen Prinsloo, investigator. It's dated the 13th of February 2023. And my understanding of this document is, I read, the Ekurhuleni Metropolitan Police Department hereby requests a copy of the following docket, gives its details, Police Station, Patfontein Subs. It continues, the COE investigation unit requests the information to assist in completing the internal investigation. EMPD reference number is as given. And then, thank you in advance. It's signed by Owen Prinsloo, COE. I take it that the City of Ekurhuleni Investigation Unit, EMPD. Do you see that?
Yes, I see that.
I read that to be conclusive proof that EMPD was fully aware of the facts and that, in fact, EMPD had initiated some form of investigation and had appointed an investigating officer for this purpose. Would that be your understanding as well?
Yes, I agree.
To your knowledge, do you know whether or not EMPD ever initiated or firstly concluded this investigation and or initiated any disciplinary proceedings against the implicated officers?
I will say I do not know currently what is happening. What I know is that Warrant Officer Kirsten recently asked copies for this docket again from me, from Integrity and Standard, and I provided here with the copies of this docket. So since from that time, this was in an initial stage of the investigation, and she recently asked me now. So I don't know at which time, and when I asked her through WhatsApp, what was the purpose for now? She said it was because of civil claim. So according to my experience with EMPD, now I'm talking my experience with EMPD, the cases that we have done. When we give them copies, they open their DR, they put them there, and we run with our investigation criminally until the member is found guilty. Those are the successes that they will have departmentally, not because of their investigation. Even if we have provided them with the copies. Remember, criminally runs for a long time. There is a serial rapist in EMPD, which Nomsama Sugu was doing. That case ran for many years, and that serial rapist was found guilty, so he was given multiple life sentence. That member was still working for those years. The member was a white officer by the name of Cummings. He was raping minor children. It's on record, this one. But his dismissal was not because of their departmental. It was because of the criminal conviction. There was another case that I have done of a white male officer who was working at K9, also raping a child of his friend. He was also found guilty. They had, Binel was, every time she was with me giving her the copies, but today she will say I didn't give her. She was following me even in Albertine. That member was found guilty at Palm Ridge Court. It was the time that member was dismissed. not by their internal processes. They will have our copies, but nothing will happen. They will park it there. So they are depending on the outcome of IPID criminal investigation. So some of the copies that we give them, those copies when we give them, they use them to wage a war against each other. Because when we give them copies, it is allegation against a certain member. So those copies